Good morning, everyone. Thank you for coming in today. This panel discussion is hosted by the London Shipping Law Centre, the YMP, the Young Maritime Professionals, and HFW. Thank you very much to HFW for sponsoring the talk and the breakfast this morning. Just by way of an extremely brief introduction, the LSLC delivers seminars and debates on maritime legal, commercial, and technical issues for risk awareness and education. And the YMP events are focused on networking and education for the more junior members of the industry, and we host a raft of events every year. I'm a member of the committee alongside Francesca Cappa and our secretary, Gerard Matthews, and who are here today. We're very grateful to Francesca and Michael for putting this event together, and for and for the excellent panel for agreeing to speak. By way of brief introduction, I recall a much brighter-eyed, slightly less grey-haired version of myself confidently suggesting in my pupillage interview that the reason I was interested in shipping was because all of the key questions in English law had been determined in shipping cases, and they would continue to be so. Now, since entering practice, rarely have I been able to give such an unequivocally positive viewpoint, and I would be much more likely to qualify that nowadays by saying it would depend on the makeup of the court, the particular facts of each case, the other cases before the court that year, litigation risk, your witnesses, your experts, etc., etc. But fast forward 5 years from that, and we've had a number of very significant cases in the shipping world where the Court of Appeal and the Supreme Court have sought to grapple with the fundamental questions which have been without clear appellate authority, for some of which for decades. And I shan't list them all, as you will be doubtless familiar with them. This year alone, we have already had 4 judgments from the Supreme Court in shipping commodities cases, and we are not even halfway through the year. Certainly in my own recollection of the bar, that is extraordinary. So today our panel is going to discuss, in particular, the RTI case and the Polar, as well as provide an update and discussion of the current disruptive geopolitical environment in the Red Sea. I hope that we can address, therefore, on the one hand, the current environment, both in terms of the Red Sea and, of course, the ongoing war in Ukraine and sanctions risk, as well as the effect that is having and will continue to have on the cases which come across our desks. So with that healthy state of the legal shipping world in mind, I feel fortunate to be sitting here today on such a distinguished panel discussing such interesting cases. I'm going to hand over to Gemma Morgan to discuss the RTI case. Gemma Morgan is a leading junior in shipping, commodities, and energy. She has been described as a razor-sharp mind, ideally suited to complex commercial disputes. And her cross-examination, and my favorite quote is that her cross-examination has been described as an art form. She is going to speak today about the RTI case.
Thank you, Ben, and good morning, everybody here, and good morning and good evening who is watching in different time zones. One typical feature of contracts, which has been getting a work out in the current climate, particularly in light of the sanctions regime and physical impediments to performance in the shipping context, thanks to geopolitical events, is the force majeure clause. Now, as I'm sure you all know, it's typical for a force majeure clause to have as a condition precedent to a party's right to rely upon it, a requirement that that party has exercised all reasonable endeavours, either to overcome the force majeure event, or to overcome the consequences of the force majeure event, or indeed both. Now, reasonable endeavours is a very pleasant sounding phrase, but it's a little bit less pleasant when you're trying to advise a client on whether or not their circumstances are ripe for a declaration of force majeure. The question you typically get asked is, well, what do I have to do? How far do I have to go in order to be considered to be reasonable in my attempts to get around force majeure? And have I gone far enough? Now, it's not a phrase which has had much judicial consideration. But if I can get the slides to work, it has been. Thank you, Ben. It's not a phrase which has had much judicial consideration, but it was considered by Nigel Tier in the Commercial Court in the Seadrill Ghana and Tullow Ghana case. And you can see on the slide there what the judge said. He said it's a phrase which effectively takes into account all relevant matters. And that includes the business interests of the party seeking to declare force majeure. So it's not a case that a party who wants to rely upon force majeure can never take into account their own commercial interests when considering what is reasonable. But they also have to take into account the legitimate interest in the other party of receiving contractual performance. And now, what may, or perhaps more accurately, may not constitute reasonable endeavours has been explored by the Supreme Court in RTI Ltd and MUR Shipping on facts which arise squarely out of the US sanctions regime against Russian companies. In that case, RTI as charterer had entered into a long-term COA for carriage of large cargoes of bauxite from Guinea to Ukraine by MUR. The COA provided for multiple shipments on a monthly basis for 2 years. So the COA envisaged, as the Supreme Court put it, a continuous flow of vessels loading in Guinea. RTI's parent company became subject to sanctions, which the practical effect of which was that it led to delays in it being able to pay freight in US dollars, which was the payment currency required by the COA. Just 4 days later, owners invoked the force majeure clause in the contract, saying that payment in US dollars was prevented, and so the COA should come to an end. Now, RTI's charterers rejected that declaration of force majeure, and instead they offered to pay in euros instead of dollars. They also offered to bear the costs of exchange and to top up any losses suffered by MUR by having to convert from euros to dollars. The practical implication there was that owners were going to be in exactly the same financial position as if they had been paid in dollars. It made no difference financially. But owners stuck to their guns and they said that the contractual requirement was payment in dollars, and the exercise of reasonable endeavours didn't require them to have to accept non-contractual performance. Charterers commenced arbitration and they claimed damages for the costs of chartering in replacement ships. Clause 36 was the force majeure clause, and I've set it out on the slide. The key element is 36.3d, which provided that there was only going to be a force majeure event which cannot be overcome, where the event or the state of affairs cannot be overcome by reasonable endeavours from the party affected. Now, contrary to the finding of the arbitrators, Mr. Justice Jacobs, on a Section 69 appeal, found that a reasonable endeavours obligation did not require a party to accept non-contractual performance, in this case payment in different currency, to circumvent the effect of a force majeure event. He rejected the arbitrator's reliance upon the fact that payment in euros would cause no detriment to MUR, and said that the contractual right to receive payment in dollars formed part of the party's bargain. The exercise of reasonable endeavours, he said, must be in support of that bargain and not towards a different arrangement. Further, he said that if a contractual right to terminate can be lost, where it is reasonable for a party to tender different performance, what amounted to contractual performance was going to be beset with uncertainty, which would be very undesirable. One can see the force in that, perhaps, but in a perhaps surprising decision, a majority of the Court of Appeal disagreed. They stressed and indeed focused on an approach which has been taken in a lot of force majeure cases, that each clause needs to be construed on its own terms. And therefore, they said this is a specific question of the construction of clause 36, and it is not a point of general principle. And the majority therefore relied upon what they described as the broad, non-technical language of the clause, and said that the real question was whether MUR accepting RTI's offer to pay in euros would overcome the state of affairs caused by the imposition of sanctions on RTI's parent company, i.e., would it overcome the delay in payment to MUR? And Lord Justices Males and Newey said that the clause needed to be interpreted in a common sense way, which achieves the purpose underlying the party's obligation. In this case, MUR be receiving prompt payment for its provision of vessels. They said in this instance, the purpose of the payment obligation was to ensure that MUR received the right amount of dollars in its account at the right time, and RTI's proposal to pay in euros would have achieved that outcome without detriment, and therefore it overcame the state of affairs. It overcame the problem of delay. And the majority relied, again, like the arbitrators, on the fact that there would be no detriment. Lord Justice Arnold, however, disagreed. He dissented, and he said that the English law presumption that parties didn't intend to give up their strict legal rights in contract without clear wording to that effect should be the starting point of the analysis. And here, what was being offered by RTI was clearly non-contractual performance, and it can't fairly be said that an offer of non-contractual performance overcomes the state of affairs caused by the inability to perform. And he said that no clear words had been used in the contract to suggest that the parties had envisaged non-contractual performance as a route round the force majeure event. Now, it's quite plain when you read the judgment in the Court of Appeal that the background, the commercial background to the case was a big factor. Indeed, they mention it, and they mention the fact that it was quite clear that MUR wanted to be relieved of the COA because it had become disadvantageous. Yet, when the decision came out, I think it felt very uncomfortable to be in a world where a party was required to accept alternative, non-contractual performance of some type, because effectively you were being asked to accept a breach of contract, but without a right to claim damages. And to use the language of Mr. Justice Tier in Seadrill, it didn't take account of the affected party's legitimate interest in obtaining contractual performance. Unsurprisingly, MUR got permission to appeal to the Supreme Court. And all 5 of the justices held that Mr. Justice Jacobs and Lord Justice Arnold had got it right, and that the majority in the Court of Appeal had got it wrong. Lords Hamblin and Burroughs, with whom the others agreed, said that this was an issue of general principle because these sorts of reasonable endeavours requirements are extremely common. And then, to the side probably of, to the echo of sighs of relief in legal departments, they held that the exercise of reasonable endeavours does not require a party to accept non-contractual performance. And the Lords gave 4 main reasons of principle, and they also looked at authority at some length and said to the extent that authority dealt with the point, it supported that approach. But the 4 main reasons of principle are this. Firstly, and I think quite interestingly, they relied upon the underpinning of causation, behind the point that goes behind why a party is entitled to get out of contractual obligations if there's a force majeure event. They said that force majeure clauses concern the question of whether or not contractual performance is impeded by a force majeure event. So if a party can overcome the impediment by exercising reasonable endeavours, then any failure to exercise such endeavours will mean that the lack of performance was caused by the failure to act reasonably, not by the force majeure event itself. And it follows, they said, that the relevant question when assessing a party's endeavours is whether they could have secured the continuation of contractual performance and thereby broken the link, the causal link, between the force majeure event and non-performance. In other words, the purpose, the object of the reasonable endeavours, they said, must be to secure contractual performance. And here, in this case, the performance which was impeded by the banking delays was receipt of payment in dollars. That was the contractual obligation that couldn't be performed. And that performance was never going to be achieved by RTI giving payment in euros instead. It might have been achieved, for example, say by MUR seeking a special license to receive payment in dollars, but payment in euros wasn't the contractual performance that was being impeded. The second point that they relied upon is that freedom of contract is a fundamental principle of English law. In other words, parties can choose the terms upon which they will or will not contract. And that point extends to the right of a party to refuse to accept offered performance that is not in accordance with the terms that they have bargained for. Thirdly, they agreed with Lord Justice Arnold and said that the Gilbert-Ash principle applies by analogy to contractual rights. In other words, clear contractual words are needed before a party will be taken to have foregone its contractual rights. And fourthly, probably the point that resonated most with those of us who would actually have had to live with the Court of Appeal's decision, the Supreme Court adopted a point relied upon by Mr. Justice Jacobs, the importance of certainty in commercial contracts. The court said that the test that had effectively been put forward by the Court of Appeal, which is there alternative performance that reaches the same result as contractual performance, but without detriment to the receiving party, was going to be far too uncertain to apply in practice. It would give rise to a huge amount of uncertainty as to when force majeure can be declared, which, as we all know, is something that one needs to take a decision on pretty quickly. So that's the Supreme Court. What are the takeaways from this decision? Well, I think firstly, happily, orthodoxy reigns and parties will not be required to tender or to accept non-contractual performance to avoid the consequences of force majeure. But second, what does that mean in the current climate? Well, I think it means that one thing one can consider is at the drafting stage, whether or not it might be prudent to include a requirement or an allowance for alternative non-performance to be offered or perhaps discussed in good faith in the event of force majeure occurring. One does sometimes see in bespoke contracts clauses which require parties to discuss in good faith alternative methods of performance, but they don't often feature in a formal force majeure clause. But the Supreme Court made it clear that if parties were express in their wording that non-contractual performance was to be permitted as part of reasonable endeavours or to circumvent a force majeure event, then that wording would be given effect to by the courts. And particularly in the context of sanctions for transfer of funds and difficulties in performing loading and discharge obligations at various ports, considering some alternatives which allow for different performance in force majeure circumstances might well be a good idea. Okay, that's all I wanted to say on RTI and MUR.
Thank you very much, Gemma. If I can ask everyone to hold questions to the end, we're going to have some Q&A for the panel then. But that's very interesting discussion and concise summary of recent decision, which I'm sure I have the opportunity to quiz Gemma on later. Kevin has a quite extraordinary CV. I struggle to see how he's packed it all in. He has spent 23 years in private practice, having been a partner at MFB and Instant Co. And he has somehow also spent 10 years in the Royal Navy and worked for the United States Department of Justice. He is currently senior legal counsel in the Navig8 legal team. Navig8 is one of the largest independent vessel managers with over 85 vessels under management. And so I very much look forward to his take on the current geopolitical situation in the Red Sea.
Thank you very much indeed, Ben. Actually, I've got a really interesting question coming out of that, but I will save it as Ben told me to. Right. Okay. So thank you for the opportunity to speak. Thank you to LSLC, everybody who organised this, and YMP particularly for giving me the opportunity to speak in my comparatively new role as an in-house lawyer rather than in private practice. I'm going to talk about the Red Sea crisis, an overview. Now that I'm no longer in private practice, I don't have to show off how much law I know. Now I can just talk about some facts that hopefully will be of interest to people. So my first slide is, where's it happening? You'll see at the bottom there is, of course, the mandatory disclaimer at the bottom of that slide, now that I'm speaking for someone other than my firm, who doesn't tend to be that bothered about PR. Or law firms don't tend to be. I'm also, of course, not endorsing any particular brand of coffee either. Other coffee shops are available. So, according to TradeWinds, the Houthis have already launched more than 100 confirmed strikes against commercial ships in the Red Sea and the Gulf of Aden over the past 6 months in an attempt to disrupt trade with Israel and target the ships of its Western allies to pressure Israel, of course, to end its war in Gaza. Now, this has involved various delivery methods, drones, missiles, attempted boardings, and indeed one hijacking. And it's reported that the strikes have so far resulted in the death of 3 seafarers and 10 Houthi fighters, as well as many more Houthis ashore when attacked by coalition forces. They've also shown the capability to carry out long-distance drone strikes in the Indian Ocean, so to the east of the picture that you see here, and also claim to have attacked 2 ships at the Israeli port of Haifa. Last month, they said that they had launched a 4th phase in their campaign and would attempt to hit any ship within their range bound for Israeli ports. And to add to that, perhaps by coincidence, perhaps not, we've also recently seen an increase in East African piracy, which of course has been quiet for some time. It's been reported that there are at least 3 active pirate groups now, and that there were 2 attempted assaults over the past week. So where is it happening? Well, you'd have had to have had your head in a bucket, really, not to know where it's been happening, but I've put a helpful slide on there for hard thinking. It's on the southern approach to the Suez Canal, particularly around the Bab al-Mandab Strait, which is the pinch point for vessels proceeding from the Red Sea into the Gulf of Aden and vice versa. I need hardly say that the Suez Canal is a very important shipping route. About 12% of global trade passes through it. And the route via the Cape of Good Hope adds some 4,000 nautical miles and up to 2 weeks in each direction to the voyage from the Indian Ocean to Europe, of course, increasing voyage times and fuel costs. Right, nice busy slide, just to keep your eyes occupied. So a quick review, some of this may not be new to many of you, of the reported attacks based on internet sources. And I've highlighted certain occurrences in red. There was one attack at the end of November of last year. That's the Galaxy Leader, which involved the abduction of some 25 crew members on board a 5,100 TEU box ship. But it wasn't long after, on the 3rd of December, that the first missile and drone attacks started. In fact, 3 ships were attacked on the first day. And then there was, as you'll see, a high number of attacks during the remainder of December, 27 in total throughout that month. Moving on to January and February. Well, at the beginning of January, the US and UK forces shot down over 20 drones and missiles and have since taken the attack to the Houthis on land. And that's contributed to the Houthis' targets being expanded from those with perceived links to Israel to also include those with perceived links to primarily the US and UK, but also Australia provided personnel support, and Bahrain, Canada, Denmark, Germany, the Netherlands, New Zealand, and the Republic of Korea have also provided non-operational support. Not quite sure what that means. Hopefully it's more than just saying, we support you, go get them. The first attack with potentially very serious consequences, of which I'm aware, was the Marlin Luanda, appropriately a tanker, a product tanker for my current role. On the 26th of January, a missile caused a fire in one of that product tanker's cargo holds, which could easily have got out of control but for the assistance of a nearby Indian naval vessel. And this was followed, as widely reported, on the 18th of February by the sinking of the 32,200 deadweight bulker, the Ruby Marsh. It took a couple of weeks to sink, and you can see both of those vessels on the slide. Well, since then, through March, April, May, and the beginning of this month, we've seen a declining number of reported attacks each month, though there were 3 last weekend, so they certainly haven't given up and gone away. I suspect that the reduction may in large part be due to the increased presence of Western countries' naval assets in the area, particularly with air defense capability, their own missiles. I didn't really manage to find anything to highlight in red there, although I did consider actually the 4th attack in March, which is the Pinocchio, but I wasn't altogether sure that they were telling the truth about that attack. Tough gig. Okay. Sorry, and you couldn't see the slide. That's the Pinocchio there, number 4. Right, okay, so moving on. What's the effect on the stakeholders been? Right, the crisis has had a significant effect on most aspects of the shipping industry. And the graphic on the slide there shows traffic density per hour square kilometre between 2015 and 2020, from which you can see that little traffic previously passed around the Cape, apart from direct voyages from the Far East to the Americas and vice versa. So far as tankers are concerned, well, as was shown by the Marlin Luanda incident, the likelihood of a catastrophic event resulting from a hit on a tanker is probably greater than any other trading ship, and many operators took the decision early on to route via the Cape. It's been estimated that the crisis will increase sailing distances by 7% for crude tankers and 4% for product tankers during 2024. That and the Russian sanctions are expected to add about 10% to crude tanker demand compared to the same time in 2022. Container vessels, well, diverting vessels from the Red Sea due to the ongoing conflict has significantly impacted shipping schedules. Taking the Cape route has disrupted planned schedules and increased fuel consumption and other costs. The rerouting has led to a ripple effect, with major transshipment hubs in Europe and Asia becoming bottlenecks, further slowing down the movement of goods. And we're now starting to see the container port congestion, or something like it, that we last saw during the COVID-19 pandemic. Berthing delays in major ports are extending up to 7 days, while dwell times in Shanghai have reached 3-year highs. This severe congestion has led to vessel bunching and forced some carriers to cancel planned port calls, compounding the problem at downstream ports, which of course must then handle additional volumes. And overall, it's estimated that the worsening port congestion has removed more than 2% of container vessel supply since March. Now, dry bulk, well, the impact here has been less than on tankers and containers, with only 4.5% of global bulk trade passing through the Suez Canal before the crisis. But daily bulk transits through the Suez Canal did fall 19% from the end of December to the end of January, compared to a 55% fall in container transits as a comparison, according to the United Nations. And one factor in that could be that a larger proportion of dry bulk shipping could be considered safer, as it's not linked to Israel or American allied countries, whom the Houthis have said, of course, they're primarily targeting. I thought I'd also mention cruise vessels. Well, along with tankers, of course, cruise vessels represent the greatest risk of some sort of catastrophic consequence if they're hit by a Houthi missile, with considerably more lives at risk. And of course, as a consumer industry, potential cruise line passengers will vote with their feet if they think that there's a risk that their cruise liner might be attacked. So MSC Cruises, Carnival, Royal Caribbean, Celebrity, Holland America Line, Virgin Voyages, Cunard, Silversea, Crystal, Princess, and many others have all been reported to have cancelled or rerouted ships as a result of the crisis. This at a time when the industry was actually quite effectively recovering from the effects of the COVID-19 pandemic. Hopefully it won't have too much of an effect on the industry going forward. And lastly, of course, there's the impact on the Suez Canal and the Egyptian economy. It provides about 2% of the country's GDP, not a huge amount, but certainly a significant one. And the dollars that are earned help to reduce the country's $165 billion public debt. Dollar revenues were reported to have been down some 40% in January compared to the same period last year. And combined with a drop in tourism, which accounts for about 10% of its GDP as a result of the current instability in the region, the country is taking a double hit. So lastly, what then have been, are, and are likely to be the commercial consequences? Well, drawing on my own experiences from private practice and colleagues in the industry, when the crisis first hit in late November, everybody was starting to dust off their charter parties. And some issues that arose, and I'm sure there were many more, were arguments brought by charterers against owners that the latter had agreed to transit the Suez Canal no matter what. Sometimes you see that expressly stated in the charter party, but we saw arguments that were to the effect that freight includes all costs, including including Suez Canal transit, if applicable, might amount to such agreement, which seems to me to be pushing it quite far. Under certain charter party wordings, the charters would insist on the direct and customary route, which of course would usually be via Suez, if war risk cover was available for the transit, no matter how expensive it might be. And of course, this threw up the age-old issue that what might be agreed on the phone via brokers, that of course the vessel would proceed via the Cape in the circumstances, doesn't always make it into the recap. And of course, if it's not in the recap, if it's not written down, then you're unlikely to be able to rely upon any of those discussions at a later stage when a dispute arises. It was found that some parties had agreed outdated war risk clauses dating back to the 1950s, which were not fit for purpose. And also, interestingly, moving away from charter parties to another form of contract, what happens when a technical manager, who will often employ the crew, considers that the risk to the safety of the crew is too great to justify the transit, but their ship owner employer disagrees? Well, depending on the wording of the contract, shipman or whatever else, there may be arguments to support the manager in refusing to carry out the owner's order based on their responsibilities for the safety of the crew and good management practice. Well, what's happening now? Ship owners still using the Red Sea face rising insurance premiums, and additional costs are often passed on to other stakeholders. For example, the redirection of Asia to Europe services in the container trade via the Cape of Good Hope has led to box ship carriers implementing surcharges. There have also been increases in ancillary costs, such as crew bonuses, and doubtless a number of contractual disputes will find themselves in front of the courts and arbitration tribunals for a number of years to come, though that may not be such of a disaster for many people in the room and watching online. One issue for ship owners to have in mind is whether there'll be P&I cover if there's a deviation around the Cape. That's far too large a topic to discuss here, but as always, communication with P&I insurers at an early stage is key. And what are the predictions for the future? Well, the practical response to the current crisis isn't the same as combating piracy. It's often been commented that following BMP-5, using armed guards and razor wire are of little use when you have an incoming missile, and that's certainly true. The only way to avoid or arguably minimize the risk is simply not to go there. The number of legal issues that are coming across people's desks on a daily basis do seem to have dropped from its height in the few months following the beginning of the crisis, perhaps because of lessons learned about what charter party clauses should be negotiated, and also perhaps because, as the apparent randomness and severity of attacks has shown that no vessel is safe, the market's approach has generally been to take the Cape route. In terms of the longer term future, when is it all going to end? When are we going to get back to normal? The advisory and broking company WTW predicted in a report last week that attacks are highly likely to continue over the next 6 months, as the Houthis have sufficient stockpiles of weaponry, despite airstrikes on their positions in Yemen that have caused dozens of deaths, as I mentioned before. They also warn that Houthi attacks on commercial shipping may continue after fighting in Gaza has ended, as a sign of symbolic support for the Palestinian resistance against Israel, which of course, however the Gaza conflict is resolved, there will still be pressure points, not only in Gaza, but also on the West Bank. Their forecast of maritime security scenarios suggests that the impact on shipping in the Red Sea and the Gulf of Aden could continue into mid-2026, even if armed resistance by Hamas against Israel has stopped by then. And that is all I wanted to say. So I will now pass back to Ben to introduce. Oh, I'm going to pass the laptop.
Extremely complex operation.
Thank you very much, Kevin, for a very interesting, enlightening explanation of what the current situation is and what we might expect for the future. We're now going to hear a case study from Michael Buisset and Caroline West, looking at a case study of on the types of facts which might arise from the geopolitical situation, which Kevin has helpfully set out, and the relevance of the Supreme Court's decision in the Polar. Caroline is a senior associate in HFW's Commodities team, specializing in commodities shipping and international trade, and somehow also, alongside that, lecturing arbitration and shipping at University of Freiburg. She's previously worked in Dubai and Australia, as well as Geneva for a number of years, but much to our gain has recently moved to London. Michael is the head of the HFW Geneva office. We're very grateful to have him in London today. He worked in HFW's Singapore office for 7 years. He's practiced in London, Singapore, and Geneva in English, French, and German, and is a qualified English solicitor and French avocat. As such, he completes an extremely well-qualified panel. And I should add that having worked with Michael and Caroline previously, they are also a total pleasure to work with, without any duress or bias. And so without further ado, I will hand over to Michael and Caroline.
Thank you very much, Ben, for the very kind introduction. Good morning, everyone, and thank you very much to be here with us bright and early here in London. It's a pleasure to be able to speak about issues which have been keeping us very busy in the last few months and years. It's true that the last few years have been marked by severe disruptions in the trading and shipping environments. We've just heard from Kevin about the crisis in the Red Sea, one of the bottlenecks of international shipping. Another one is the Panama Canal, which has also seen major disruption in the last few months. So we are in a world where the future is uncertain. We have a bunch of people who are firing at ships in the Red Sea. We have an unprecedented sanctions regime which applies to shipping and trading contracts, which has made the world of contractual interactions much more complex. And we've seen it and heard it from Gemma earlier, how the courts are responding to it. We had a few decisions which were pushing flexibility in the application of the contractual environment. And now the Supreme Court taking a view and going back to certainty, which I think in this uncertain world is quite a welcome move. And we'll take you through a case study. So we'll try and make it a light-hearted case study based on true facts. And we'll make you work a little bit to see whether you agree with charterers or owners in a case study which will take us to the Red Sea and envisage a Houthi attack in December of last year, and see what you think, whether charterers or owners are right. And then we'll come up with a solution and conclusion, and perhaps open the floor to discussion on what this entails for all of us. Let us start with setting the scene and sharing a few background facts for this case study. Caroline will take us through the background of the case we'll discuss.
Thank you very much, Michael. Could I have the clicker for the presentation? Thank you very much. Excellent. Okay, so I'd like to set the scene. As they say on Netflix, this is based on a true story. So to set the scene, we have a vessel that is voyage chartered for a voyage from Fujairah in the UAE to Tallinn. And we've got a charter party that expressly refers to this being via the Red Sea/Suez. The common and direct route for this particular voyage is via the passage of the Gulf of Aden, Red Sea, Suez Canal. And at the time, this is known to be an area of risk and danger. So prior to transiting this area, in November 2023, ship owners take out additional insurance to increase their hull and machinery insurance to cover this particular voyage. Unfortunately, the worst happens, and during the transit, the vessel is struck by a Houthi missile. The vessel sustains significant damage and has to undergo temporary repairs before it can complete its voyage. In this scenario, these repairs cost around $5 million. So prior to discharge, owners declare general average. A general average guarantee is provided by cargo underwriters, and a general average bond is provided by bill of lading holders. The general average adjustment is issued, which concludes that about 2.6 million is due to ship owners from cargo interests. So the scenario that Michael and I are going to be debating here is, do cargo interests have to pay this general average request? But before we get to that, let's look at the particular relevant contractual terms. We've got a charter party which is concluded on the BP VOI 4 standard form with amendments. BP VOI 4 contains clause 39, which defines war risks as including acts of war, hostilities, warlike operations, acts of terrorism, acts of hostility or malicious damage, and which goes on to say that where there may be exposure to war risk, owners are entitled to cancel the charter party any time before loading, to stop loading, stop proceeding, and at charterer's expense, divert to an alternative discharge and divert the vessel at charterer's expense. In this scenario, we also have some bespoke clauses in the recap, particularly relating to war risk insurance cover. These clauses are set out on the slide there. It's worth emphasising that there is a bespoke clause saying that any additional insurance premia, including but not limited to those in respect of hull and machinery, crew, P&I, kidnap and ransom, and crew bonuses, shall be for charterer's account, max $40,000 for charterer's account for any additional insurance premium, except for crew bonuses, which is to be max $20,000 for charterer's account. There's a further clause headed war risks, which also emphasises that any additional premiums payable by owners in respect of war risks incurred by reason of the vessel trading in excluded areas shall be for charterer's account. So in short, we've got some clear bespoke clauses stating that additional insurance premium costs shall be for charterer's account up to this 40,000 cap. What of the bills of lading? Well, in this scenario, we've got 6 bills of lading issued on an intertank bill 78 form. The bill of lading incorporates the charter party wording we've just looked at, and it has the usual wording on the reverse of the bill of lading, stating that general average is to be settled in accordance with York Antwerp rules. So we have a vessel which has sustained damage from a Houthi missile strike, and owners have sought to recover a general average contribution from cargo interests in the sum of around 2.6 million, pursuant to this general average wording in the bill of lading. Cargo interests are perhaps unsurprisingly not happy to receive such a substantial demand for a GA contribution, and cargo interests contend that they have no liability, arguing that on the true construction of the bills of lading, the ship owner's sole recourse is to seek reimbursement for repair costs through additional insurance coverage obtained in accordance with the terms of the voyage charter party. So at this stage, Michael and I are going to put our advocate hats on, maybe that should be wigs, and argue the case for each side. Michael is going to take the part of ship owners and argue that this GA contribution should be made, and I'll be taking the part of cargo interests and charterers and arguing that this outrageous demand for 2.6 million, of course, is not going to be paid. But before I get too partisan, let me hand over to Michael.
Thank you very much, Caroline. Before my life as a lawyer in Geneva, I was based in Singapore for 7 years representing ship owners. So I'll try and get into the ship owners' shoes today and argue the case for the owners in facing the consequences of this Houthi attack, and to see whether the owners should be entitled to recover their GA. So the cargo owners, represented by my learned friend here on my left, will be claiming that the ship owners should be precluded from recovering from the BL holders the losses arising out of the risks for which the insurance was obtained. They will tell you that it would be a remarkable result. It would be absurd to hold a charterers retain responsibility for the risks inherent in trading in a area for the very risk against which the extra premiums were paid and they were specifically asked to contribute. In fact, they will say that they would be paying the premium for nothing. And indeed, this is an argument which has some force and which was considered in a case called Evia number 2, which described this as a remarkable result, and which no doubt would only satisfy war risk insurers, who would find that result very attractive. They will have the premiums paid, and they won't have to fork out the payments for the risk covered. However, although this argument has some force, we have to consider the contractual nexus between owners and charterers in these circumstances. If there were no extra insurance, the ship owners could not safely accept to go through an area outside the charter party limits, because the ship owners would be trading their ship uninsured. So someone has to pay for the extra insurance. Someone has to decide that the ship should trade through a risky area and cover the extra costs linked to that. There would ordinarily not be any incentive for the ship owners to do so. Why should they pay the extra premiums themselves? It is, after all, the charterers who are asking the owners to go through that risky route. However, when the charterers agree to pay the extra premium, the position is different, and the ship owners carry neither the risk nor the financial burden of widening the charter party trade limits. By paying the premium, therefore, I argue that the charterers obtain a benefit, the benefit of being able to send their ship on a voyage which the ship owners would not otherwise allow to perform. And this is not saying that the charterers thereby obtain the right to send a vessel on such a voyage risk-free. It is a fair commercial negotiation. The ship goes through that area, but in order to go through the area, there is a financial burden for the charterers in having to pay the extra premium which is required to go through and to ensure the ship is insured for the passage. In respect of the liability which the cargo interests face, there is under English law a common law right which is regulated by contract, which is general average. This is a valuable right which is so enshrined in English law that it is a clear, and you need a clear agreement to that effect in order to displace that right and to have a code which would entitle the parties not to rely on general average, but to only look at the insurers for the damage which has arisen. Under English law, there is no principle, we say, exempting charterers from liability, merely on the ground that they have directly or indirectly provided funds whereby the ship owners insure themselves against the relevant loss or damage. In the absence of a joint insurance regime in the contract, there is simply no authority for the proposition that where a contract requires a party to contract to insure, the parties look only to the insurers for the liability that arises. This situation would be different, of course, if you have a co-insurance regime with a joint name insurance arrangements in place, where the legal consequence would be that the parties cannot claim against each other in respect of the insurance loss. But no such co-insurance regime exists in this charter party. Therefore, the owners should be entitled to claim the losses which arise out of the GA, the general average claim.
Thank you, Michael, for putting the case for owners. Let me now turn to charterers and cargo interest position. Now, charterers and cargo interest position is, of course, that no general average contribution is payable to owners at all. This is, of course, a one-off voyage, and the parties have included a bespoke clause in their charter party, which states that additional insurance premia payable by owners in relation to war risks shall be for charterers' account, up to that cap of US dollars 40,000. The parties have therefore made a specific allocation of the known risks of transiting this area by establishing an insurance fund for the payment of losses arising from transiting that area. This fund is the insurance coverage, and the insurance coverage only, we say. The only place that owners can look to recover these repair costs is the insurance taken out to cover just that eventuality. Owners do not get two bites of the cherry here. They don't get charterers to pay the insurance cover and then demand that charterers also make a general average contribution. In particular, it is worth remembering that in circumstances such as these, it is not ship owners who have a financial interest in getting this general average contribution, but it is instead the insurers stepping into the shoes of owners and making a subrogated claim for this GA contribution. This result is remarkable. Charterers both pay for the privilege of taking out this insurance, owners say, but also when a claim is made on the policy, owners say charterers then face a subrogated claim from those insurers for the general average contribution. Well, this is utterly remarkable, commercially absurd even, we say, because this would effectively result in charterers needing to reimburse insurers for the very loss against which charterers have themselves insured. That cannot be correct. I think Mr. Buisset put the case for charterers well when he said that this would effectively mean that charterers get no benefit at all from this insurance which they've paid for. There is authority that deals with this in the AVIA number 2. In that case, Lord Roskill mentioned that it would be and determined that it would be a remarkable result if charterers had to repay the owners the premium for extra war risk insurance, only to find that if those insured risks materialise and cause damage, then the war risk insurers, upon payment of the claim, become subrogated to owners' rights against charterers. I would say it makes no difference that the AVIA 2 concerned a claim for breach of safe port warranties, and the present case concerns general average contributions. Charterers would posit that the case here is even stronger when we're talking about a GA contribution, a context in which charterers and cargo interests are not at fault, and they're simply being asked to make a contribution according to the usual York-Antwerp regime. The above sort of neatly explains why charterers are not liable for a GA contribution. What of cargo interests under the Bill of Lading? Well, our position is that the same logic applies there. Charter party language creating an insurance code and a complete fund for the payment of repair costs is incorporated into the Bill of Lading, we say. And the salient point is that this code involves an agreement to look to the insurance and not to GA costs. And the words charterers and or cargo interests are to be read interchangeably. So that's the position for charterers and cargo interests. We said at the beginning that this was based on a true story. So I think now we want to go and move on and look at the case, the Supreme Court judgment in the Polar, which tells you which side was ultimately proved to be correct in this, owners or cargo interests.
Thank you very much, Caroline. Before we come to the solution, perhaps we could have a quick show of hands and see how the room is feeling, if anyone is siding for the charterers or whether anyone is siding for the poor owners on this side, on this occasion. So who thinks the charterers are right? Who thinks the owners are right? Okay, so we have a familiar room, a room familiar with the decision perhaps in the Polar, which has been talked about quite a bit, and which is quite close to my heart, because it was a case which I followed with my partner Richard Naylan a few years ago, who is very involved in the piracy attacks which hit the same area of the world which we are just discussing now, the Red Sea and the Aden Passage from 2008 to the late 2010s, 14, 15. And I always felt it quite remarkable when I was traveling with Richard. I was talking to clients about demurrage disputes, and he had always very exotic stories of freeing hostages in that part of the world. And I think it was a relief for him and for owners to see the clarification which was given by the Supreme Court in the Polar on issues which are very very standard in shipping cases, incorporation of charter party terms in bills of lading, and the question of in the circumstances in which a complete insurance code can be applied to a contract. Again, we come back to the MUR shipping case Gemma discussed earlier, and the Supreme Court actually finding for certainty in commercial contracts, as opposed to leaving it on a case-by-case basis on assessment of whether the parties have agreed a code or not, or whether the parties are able to rely on force majeure. So let me take you very briefly through the facts of the case, which are not dissimilar to the facts we've just described. 10 years on, 15 years on, same area, different bunch of nasties hitting ships with different techniques, but the insurance problems and questions are very similar, and are therefore worthwhile discussing. So here in the Polar, the Herculita Maritime versus Gunvor case involved a charter party for a voyage in October 2010 from St. Petersburg to Singapore. The common and direct route was via Suez and the Gulf of Aden. And at the time, the risk of piracy attacks was notorious. Prior to transiting the area, the ship owners took out additional insurance, including for kidnap and ransom. And indeed, the charter party clauses and a bill of lading clauses, which Caroline described earlier in our case study, were identical to the ones in the Polar. So the charterers were asked to contribute to the payment of the premium for the insurance taken out. Now, the ship was hijacked by Somali pirates, and she was taken for about 10 months until the owners agreed to pay a ransom of $7.7 million in order to free the ship and to enable her to carry on the voyage. And prior to discharge of the cargo in October 2011, after the ship was released, the owners declared general average, asking the cargo interest and bill of lading holders to contribute by way of general average bonds. In due course, a general average adjustment was published, which concluded that about $4.8 million was due to the ship owners from the cargo interest, Gunvor. Gunvor denied liability, and the ship owners commenced arbitration under the GA guarantee and bond to recover their general average claim. The tribunal was constituted of very knowledgeable a bunch of arbitrators. We had two barristers, Timothy Young, QC, Dominic Kendrick, QC, and Simon Gold. So a very experienced and black letter law tribunal who favored for the cargo interest on all four issues, which we'll come to in a moment. And they decided that the cargo interest did not have to contribute in GA. So that there was an insurance code, and that the cargo interests had therefore no reason to contribute in GA, and that the owners only had to look at the insurance for recovery. The case was appealed to the High Court, and in the High Court, Sir Nigel Tier agreed with the arbitrators that the owners were precluded from claiming against charterers due to the insurance which was in place, and that the relevant clauses had been incorporated into the BLs. However, he disagreed that the incorporation meant owners were precluded from claiming against the cargo interests. And the Court of Appeal agreed that the cargo interests did have to contribute to GA. The case then came to the Supreme Court. And it's interesting that the 4 issues which were discussed in the arbitration were also the 4 issues that made it to assessment in the Supreme Court. And I'll hand over again to Caroline to give us the answers and how the Supreme Court looked at those issues in detail.
Thank you, Michael. So the Supreme Court dismissed cargo interests appeal and held that owners succeeded on points 1, 3, and 4. On the proper interpretation of the Charter Party, it was found that the relevant, and particularly the relevant war risks and Gulf of Aden clauses, the owner was not precluded from claiming against the Charter in respect of their losses, and no insurance fund was established. Material parts of the clauses were incorporated into the bills of lading. And on the proper interpretation, the clauses did not prevent owners from claiming such losses from cargo interests. On the last question, the court decided that the clauses that the wording should not be manipulated, such as to substitute the word charterers with bill of lading holders. The clauses made sense as they were. Let me unpack that a little further. In particular, the Supreme Court examined at length whether an insurance code or an insurance fund had been established here in the Polar. The Lordships considered the 2 cases in which an insurance code was found to exist, the Demise Charter Party in the Ocean Victory and the Time Charter in the Avia 2. The Supreme Court was reluctant to expand those cases beyond their particular facts. In the Ocean Victory, this case did not avail cargo interests. That case was about a bareboat charter which required insurance to be taken out in the names of owners and charterers as co-assured. And it is a principle of insurance law that where there's an action between 2 parties who are assured against the same risk under the same policy, that action is not permitted. Contrastingly, in the Polar, owners, charterers and cargo interests were not co-assured. It is therefore different from the Ocean Victory case. When charterers and owners are not co-assured, there is a high threshold to be satisfied before implying any kind of insurance code or fund. And the only case where this sort of took place was the Avia number 2, but the Supreme Court cautioned against relying on that particular decision unless particular features which were identified by Lord Roskill in that particular case similarly applied. In the Polar, it was found that there would be no remarkable result, to use Roskill's moniker from the Avia, absent implied insurance code, because charterers did obtain a significant benefit of being able to transit through an otherwise prohibited zone, the Gulf of Aden, in consideration for payment of the war risk premium. Having concluded that the Charter Party did not include an insurance code or fund, implicitly it logically followed that there was no insurance code or fund in the bill of lading contracts, which incorporated the Charter Party terms, and cargo interests accordingly had no defence to their sort of general average contribution requirement. So that is the decision of the Supreme Court in the Polar. My colleagues at HFW, Richard Naylon and Jenny Salmon, were involved in that case. And I think the lessons that you can learn from it are that the Supreme Court was very clear in emphasising that if the parties had wished to provide that there should be no right of recovery or subrogation, that could have easily been expressly stated in the Charter Party. Therefore, think about it when drafting Charter Parties. If you want to exclude subrogated recoveries by insurers say so. The other lesson learned is that charterers, that owners will not be held to have given up rights to general average contributions unless there is a clear intention to do so. The judgment clearly limits the scope of this insurance code doctrine and emphasises that an insurance code won't apply without a clear intention from the parties, and there are high thresholds to be met there in terms of evidence. But the last point I wanted to draw out is this. In considering the issue of whether there was an implied insurance fund, the Supreme Court considered whether owners would have been entitled to refuse to transit the Gulf of Aden under the war risk clause, despite the Charter specifically providing and expressly referring to proceeding via Suez Canal. Well, the Supreme Court endorsed the decision in the Product Star and the Parwan Wisdom, and considered that the owners had agreed to pass through the Gulf of Aden, and in the circumstances it will be inconsistent with that express agreement to construe the particular war risk clause in the BPVOI in such a way to permit the owner to refuse to transit an area on account of the piracy risks. In other words, owners had essentially accepted that risk by entering into a charter party which expressly referred to Suez transit. And the court considered that it's only if there was a qualitative change in the nature of the risk since the charter party was entered into when where the war risk clause might be relied on. So I think that is of particular interest in the Houthi context and the context of what's happening in the Red Sea. And the Supreme Court did in fact note the immediate relevance of this judgment, which, although it arises out of the piracy crisis of 2010s, that particular finding in relation to express wording in charter parties and how that interplays with war risk clauses is just as relevant to the Red Sea situation. So I think we wanted to close by just exploring what lessons can be learned from it, how to mitigate Red Sea risk in charter parties, and what sort of commercial considerations should owners and charterers be thinking about.
Thank you very much, Caroline. Very quickly, just to close off with a few final remarks before we open the floor to questions. It is clear that all contracts turn on their own words, and I think one of the points which has been repeated quite heavily in the context of the Red Sea crisis, that each charter party turned on its own clauses. But just by way of general assessment, it is clear that you have to look at whether any express obligation in your contract overrides your war risk clauses. So here in this case, in the Polar and in our case scenario, we had an express agreement for the parties to go through Aden, and this overrode all other war risk terms which have entitled the owners to take the Cape route. They have specifically agreed to go through Aden and through the Red Sea, so therefore that were overriding principles which were binding the parties. Now, unless the situation changes rapidly, and we've seen it was changing very rapidly between November and December, and as Kevin explained earlier, the situation is still subject to change. I mean, people are looking now at 2026. If there is a heightened risk of attacks or a different type of attacks, then it may well be that owners can argue under the charter party they entered into that this was not a risk they undertook to bear when they entered into the charter party, that the risk has now heightened, that the insurers are reassessing the position. So it's always a factual assessment of the situation on the ground as well to take into account. Then looking at which party has to bear the loss of cargo, for example. And now we've seen, and the Supreme Court has re-emphasized the right of general average, and there is not a right which can easily be avoided. It's a primary principle of English law, and you will need to have express terms in the charter to overcome or to defend any such claim under GA. have a look at force majeure clauses. So mainly if you are an operator and a cargo trader, you may have some obligations to deliver the cargo within a certain time frame. If you are unable to, or if you're exposed under the charter party terms, maybe your sale contract will permit you to declare force majeure, at least to save the cost of delay, because if you are going via, or if the owners are entitled to go via the Cape, there will be liability for the extra cost of delay going the long route. Some cargoes may be perishable, so that may also not only be a question of delay, but also a question of loss of the cargo. So have a look at the force majeure clauses. Most force majeure clauses will entitle you in a circumstance where you have an increased risk or unforeseeable event, a heightened risk in the area, will entitle you to claim the delay as part of a force majeure provision. So in that case, don't forget the notification provision. So I hope the discussion has been of interest to you. I hope you had as much fun as we had in preparing it in listening to it. And I would like to open the floor to questions or to general views of the panel.
Firstly, I just want to say thank you very much to all of our speakers today on behalf of everyone here. And thank you to Francesca and HFW and LSLC for organising this event. So thank you very much. We have, I think, just 5 minutes for 1 or 2 questions. So I would like to now open the floor to any questions. We have one online if we go on.
Hello, just a quick question for Gemma about the MUR matter. Did any of the courts consider the issue as to whether payment in euros or accepting payment in euros could be seen as an attempt to circumvent the sanctions regime, and whether that was a consideration at all?
I don't think so. I haven't, that doesn't ring a bell, but I don't think they did, no, but I'm not entirely sure, but I don't think they did, is the answer to that.
Do you think that would be an issue for the owners in that situation?
Well, if it was an attempt to circumvent sanctions regime, which would impact on them, then yes, they would have a potential ground for saying they weren't entitled to accept. And that's certainly an issue which I know has come up often in terms of whether or not an owner is entitled to accept payment. And that's caused quite a lot of problems for quite a lot of people. So yes, that would be a potential point. I think the point there was that because euros would have been an acceptable form of alternative payment, then that's why RTI offered it. But one argument which, well, no, I'll leave it there.
Thank you.
I don't know if it goes any further to answer your question, but I seem to recall from reading the judgment that it was agreed that the proposal would not be in breach of sanctions. It doesn't quite answer your question, but certainly that was taken as a given so far as the Supreme Court was concerned. The parties had agreed that either at that stage or earlier.
Well, it's an interesting question because it's a question which has fueled quite a lot of arbitration and litigation, because parties in doubt preferred not to be in breach of sanctions and preferred to have the decision of an arbitration tribunal or a court forcing them to pay rather than paying and then having to face the consequences of fines or prison sentences.
Thank you. Do we have any questions from any more questions from the crowd, audience? We have one question from online, and with apologies to Caroline, because she was on the wrong side of her partner in the argument, and also the wrong side of the Supreme Court. But this is making a similar point. It says, paraphrasing, isn't it the case that cargo insurers would also be insured for that risk, and so they're not having to bear that cost themselves?
I mean, I think that is true, that cargo insurance is very much involved here. And as you say, then the Supreme Court ultimately rejects cargo interests appeal. So yeah, I mean, it is a valid consideration that really, although we've got the name of an owner and a charter in the case, behind that are insurance interests. You're right. So yes, I think that's a very valid point from the question.
I had a quick question for Kevin, and not asking you about Navig8's particular facts, but I mean, just how much traffic is still going through, and what's the sort of typical vessel that's still going through Suez?
Well, I think it's reduced considerably now. I haven't tracked sort of, when a particular shipping company or operator has said that they are going through or they're not going through. But obviously the numbers show that the amount of traffic has decreased considerably. I think it's probably fair to say that the majority of tanker owners, if not all, I don't know, have decided that actually it's an unacceptable risk because you are in fact transporting a highly combustible liquid in most cases. But bulk trade is still going through, I think, for the reasons that we discussed. Cruise lines, I'd be very surprised if many are going through. I suppose the one that is more difficult to predict is the container operators, because at various times, various ones said we're going through, we're not going through. And yet, if you just look at the names on the side that I didn't put up of the recent attacks, then you see, for example, there are a number of MSC vessels there. So clearly they are still transiting. I think, the numbers are down. Will they continue to decrease? It's all going to depend on the geopolitical situation. I suspect that having naval assets in the area in increased concentrations, such that it looks like they are sort of acting as goalkeeper for a lot of missiles, may encourage more people to send through the Red Sea, but in order to get to Suez. But actually, I think my personal perception is that it's generally recognised that the risk to life and the environment, and as a sort of a remote firm, really, property, because that could be replaced, as too great to justify transit.
Any more questions from the audience?
May I just ask my cheeky one? I'm breaking protocol, so I'm on the same panel as you. But I was interested in your comment at the end about negotiating non-contractual performance. And it seems to me that if you've negotiated non-contractual performance, doesn't that become contractual performance? And I've read this elsewhere from other commentators, and I've not really kind of understood it. As I understand it, what you can do is you can say, well, we're going to agree to sit down in good faith and chat about non-contractual performance. Well, that doesn't mean anything, does it, really? Because it's very, very difficult to prove a breach. Well, you can say you can not turn up, but otherwise it's difficult to prove a breach of good faith. Not reasonableness, but the simple good faith. You can do that, but actually that's an agreement to, or it's something close to an agreement to agree. And an agreement to agree is not, not legally enforceable. And then you sit down and you work out what the contractual non-performance might be, which actually I think becomes contractual performance. And could it be anything other than in your list of force majeure events, saying not being able to make payment in the state currency, and then perhaps staying somewhere else or there, but but being able to achieve the same situation through payment of another currency? I can't really see any way, but you'll correct me, I'm sure, I can tell from your face, of actually coming to something which is going to be of any use other than simply lengthening the list of force majeure events.
Well, there's certainly, I disagree with you on one point, there's certainly one thing you can do, which is come up with a list of force majeure scenarios in which the parties will consider, or obliged to consider, you can try and imagine the wording, but obliged to consider performance by alternative means. But what one does see, and I haven't seen it particularly in the force majeure context, but definitely in other contexts, is quite a detailed clause requiring parties to negotiate for a particular and only in circumstances where, for example, the language no reasonable alternative can be agreed by X date. So then it moves away from an agreement to agree, and it becomes very much an enforceable an agreement to discuss whether or not there is an alternative available. But you're right. I mean, the blunt point is, in many of these cases, if both parties want the contract to continue, they sit down practically and they agree to vary the contract. I mean, that's the point in RTI and MUR is that MUR didn't want to carry on. They wanted out. And that's why they didn't say, oh, great, euros, fantastic, lovely. So in 99% of the cases, if the parties both wanted to carry on, they're going to agree, vary. But I do think that there are ways in which one can oblige one's counterparty, if they're prepared to agree to the terms, to negotiate to come up with an alternative. So if no reasonable alternative can be provided, that the contract will do. Courts do, as a personal experience of, courts are willing to read the letter of those, make sure the parties negotiate.
Thank you. Well, thank you very much, everyone, for a fascinating discussion. I would like to say thank you very much to our panel again. I'm sure people will be circulating around if people have any more questions afterwards. But thank you very much.
Before we close, first of all, there is just one thing from our side. Thank you very much to HFW for hosting and for sponsoring the breakfast, and for everyone for this early morning, for Navig8. Kevin, thank you very much, and Quadrant, of course. And I would like to invite you all to stay a bit longer. There is more food, so if you fancy, or coffee to keep us awake. And also we have our next event, which is going to be held on the 26th of June here. And it's on commodities fraud. How reliable is the victim recourse under the security and insurance arrangements? And that's all from our side. And thank you very much, everyone, again.